The allegations are not, gee, there could be all kinds of things that are happening. The allegations are that there are, he claims, affidavit evidence is what he's required to prove of a violation of 351713B or 351710D2, which is the failure of a campaign committee. Not of Allen Freeman, by the way, just of his campaign committee. Neither of these have anything to do with him individually, although he's been named as a respondent, to fully and accurate report loans or of some sort that he alleges were received by him, or debts or that kind of thing. If you take a look at Form 31N and the instructions that the Secretary of State puts on that, outstanding debts occur when money is owed and the invoice has been outstanding for 60 days or more. JPL Associates was contracted with by Allen Freeman's campaign to provide some services. They were supposed to give him an invoice that he was supposed to approve, and he was supposed to approve the media commercial time that they were booking. He didn't approve any of the bookings in the documents, or the bookings in the documents attached to the complaint, and expected only to be invoiced for approved and authorized bookings. But nonetheless, JPL was to be paid on presentation of the invoice, and they presented an invoice to him. He didn't just sit on his hands saying, gee, they've never presented invoice, so I don't need to worry about it. He had his treasurer contact JPL to try to get an invoice from it. He personally contacted them, left a phone message saying, please tell me what, if anything, I owe you so that I can properly report on my campaign finance report. Giving Mr. Longstreth's criminal issues and JPL's criminal issues, I suppose it shouldn't surprise us. They never got a call back, and they never got a response back on that. So he calls me, my client, Allen Freeman, calls me and says, well, what do I do? And I say, well, I don't think you can make up a number and report in a campaign finance report as a debt or a loan or an in-kind if you don't know whether you had a debt or a loan or an in-kind, and you don't know what the amount is. But I'll call the Elections Commission. I explained it to Phil Richter, and he agreed that that made sense, and I told my client, and that's what he did. You know, we are more than willing to accurately reflect invoices and debts that we know about and can identify with some know what the number is. But to claim that we have violated the law by failing to report an invoice that we never received or failing to report a debt for which we never had an invoice is simply contrary to the law. I understand, you know, Mr. Hicks is concerned that this is the tip of the iceberg and there must be a lot of stuff out there. A lot of people believe in politics, you know, that there's a lot of stuff out there with respect to a lot of candidates, and maybe there is and maybe there isn't. But the jurisdiction of this commission with respect to complaints is it has to be based on personal knowledge of the candidate, or excuse me, of the complainant, that establish all of the facts necessary to say that there was a violation, and that hasn't happened here. And therefore we ask that there be a finding of no violation and the matter dismissed for that reason.
Mr. Chairman?
Yes.
I have a question of Mr. Brey with respect to the services that were rendered. Did you try and get a guesstimate from another firm that does the same kind of work to at least put on the campaign finance report, either in services rendered an approximate amount or in the in-kind documentation of the in-kind contribution based on what's usual and customary for those kinds of services?
There are two problems with that. First of all, we didn't know whether it was a gift, an in-kind, a loan, or whether in fact, as Mr. Hicks points out, a lot of these were done not for him, even if his name appears on them, but for another candidate, Gene Schmidt, I believe. And secondly, we would be violating Ohio's campaign finance laws if we put down a number that we knew was not accurate. And a guess, even if it's estimated by somebody else, would necessarily be a false and inaccurate statement. And we're not allowed to have false and inaccurate statements. And in fact, the rules don't permit us to put down an estimate of what we think we might have been billed if we were in fact billed for something.
In some of the documentation that was provided to the commissioners, Mr. Hicks is alleging that documents show that the reported expense for the campaign was about $14,000 and change. And then he also provided documentation from various TV stations that show quite a bit more. They have the Freeman's name on the invoices from the TV stations, totaling, I think the last I totaled up was like $60,000-$70,000. So these invoices exist. Are you aware of those invoices?
We are since we got the complaint. We hadn't seen the invoices before that. What I would point out, though, is most of those invoices have a Freeman-R-Ohio State representatives. And if there are multiple candidates, as Mr. Hicks points out, there were here, they don't necessarily list them all. So some of these invoices may have been for Mr. Freeman. Some of these invoices may have been for Gene Schmidt or another candidate. And the invoices themselves presumably show the gross amount that the station was charging various candidates. But even though Mr. Freeman's name appears on there, it is by no means clear from those documents, even that those are all amounts that were attributed to his advertising.
Reading Mr. Freeman's affidavit that he presented on December the 11th, 6 days ago, he's saying as of that date, he still hasn't received an invoice from JPL. Is there any reason for that? Are they still in business?
I believe that I don't know other than what I read in the paper, but my understanding is that the U.S. Attorney sees all the assets of JPL, and that although presumably, Jeff Longstreth could, on behalf of JPL, issue an invoice that would then go to the amount that the U.S. Attorney is holding. I suspect that he sees no reason to do that. That's his issue of what he might be doing or might not be doing. But our issue is we can't report debts that we don't have.
Can I make a comment, or can you let me know when I can make a comment?
Go ahead.
So we could talk about the spots. It was easy for me to confirm the spots with at least one local TV station that they ran dual 15-second spots. I actually provided a link to Allen Freeman's 15-second spot that he touted on his own Facebook page in there, but we can talk about the media stuff. I think it's clear, and I think the rope-a-dope's clear that's going on. However, Mr. Brey Mr. Freeman have not addressed at all my personal direct knowledge of campaign staffers for Mr. Freeman staying at local hotels and being paid to spend full time working for Mr. Freeman, that I put pictures and video links within my affidavit. So why was that never reported? Where is any reporting for bulk mailing for Mr. Freeman? So none of that was reported as well. Just compare, Gene Schmidt, who was also part of Teen Householder, reported a little less than $300,000 of expenses on her campaign. Mr. Freeman reports $14,000. If citizens are ever going to be able to believe in the integrity of campaign finance disclosure, this is a big case. And Don Brey's excuses notwithstanding, it's nonsensical that not only when these things happen, but in the 4 months since my affidavit, what have they done to contact any of these other entities? Frankly, where is the contract from JPL that they say they'd signed? Also, people like Gene Schmidt and other candidates, they never got invoices from JPL. They got invoices from a company called Constant Content, which is another Jeff Longstreth's company. And by the way, Mr. Brey, tell the truth that you did represent Jeff Longstreth and you have a long history with him. What's worrying to me is that this becomes an incestual thing where you've got people protecting each other. And at some point, this commission and others is going to have to try to get to the bottom of this if there's going to be any integrity restored in campaign finance reporting and disclosure in Ohio. But by the way, I'll leave with this too. What about the campaign staffers? What about the bulk mailing? Maybe Mr. Brey can address why those don't show up anywhere either.
If the commission wants me to address the bulk mailing, we didn't know anything about the bulk mailing. I mean, bulk mailing was sent out presumably for various candidates. We can't report what we don't know. And by the way, I'm sorry, can you hear me? I don't.
Yes.
Yes. He's asking, well, we could have done this, we could have done that, we could have done the other thing. Here's what we did do. We talked to Phil Richter, and I realized he doesn't speak for the commissioner, and said, what do we do when we don't have an invoice? Do we report something? Now, Grant, I did not ask him, should we check out and see if there's some other way we can make a guesstimate of it? And the reason I didn't do that is because you're not allowed to make guesstimates legally on your campaign finance reports. I have no doubt that if there had been a proper notification, as the vendor was required to notify candidates of debts or in-kinds or that sort of thing, that my client would have reported it. But we didn't get that notification. And, you know, for whatever reason, the ability or perhaps the incentive for Mr. Longstreth or his company, JPL, to provide additional information just doesn't exist right now because he has other issues presumably on his mind.
Did you inform Mr. Richter that you were talking about hundreds of thousands of dollars or on invoices, or did you minimize the scope of what you were talking about when you said you talked to him?
I don't know what the amount is. You say you are speculating what the amount is, but you don't have any personal knowledge what the amount is either.
I do. I can confirm the invoices that are in the FCC database. So that's so it's not that hard to confirm stuff that's happening.
Yeah, I think I don't think this needs to be a discussion between you two. Mr. Brey, I have a question. I understand from reading Mr. Freeman's affidavit, he's indicating that his committee contracted with JPL Associates to provide media services, and that he is waiting to get a final bill from JPL Associates so that he can clear his books, if you will. And as of 6 days ago, he said he's had no contact from JPL. How long does this go on, and what do you do to finally get this resolved?
Well, what do you do when you've sent a check to somebody and it never clears? What do you do when somebody mows your lawn and they never send you an invoice? I mean, you know, you keep reporting that what you know factually to be the case. At some point, you know, I suppose at some point the campaign committee would have to be wound up, and I presume at that point, in consultation with the Secretary of State's office, we would, you know, try to figure out what do we do about the fact that we probably have had some services performed by JPL that we don't know what the amount is and have never received an invoice for.
All right, so you would acknowledge that as far as the expenses to Mr. Freeman's campaign, there's more out there, more expense than he's reported to date. Is that a fair statement?
Not in terms of, if you mean by expenditure or contribution, no, because they have specific definitions. If you say, do we suspect or speculate? We have no personal knowledge, but we do speculate, just like Mr. Hicks speculates, that there's probably some other things that JPL did for them. I think that's probably true. I think it's a fair speculation, but it's not an affidavit of fact or knowledge. You know, I think there's good reason to believe that something's out there, which is why the treasurer of the Allen Freeman campaign, why Allen Freeman personally tried to contact JPL and say, why please send me a bill, which they didn't do. So yeah, we expect that there's probably something, but we can't report it until we know what it is. And suspecting does not establish a sufficient evidence of a violation for purposes of this commission. But I'm not going to be disingenuous. Obviously, we do suspect there's something else out there.
Mr. Chairman.
Mr. Chairman.
Yes.
Go ahead.
Mr. Chairman, this is Commissioner Kreitz. Based upon Mr. Hicks's testimony this morning and based upon some of the statements that have been made by Mr. Brey, I'm going to have to recuse myself from any kind of participation in this matter, as well as the deliberation or any kind of vote. So I'd like to have the record reflect that based upon what I have heard this morning, Commissioner Kreitz is recusing himself. Thank you.
Okay.
Mr. Chairman, this is Commissioner Tavares. I do think, based on the conversation we just heard, that there are outstanding invoices, which means services were in fact performed for the candidate. We know that there in fact were commercials, so somebody authorized that. So that is either an in-kind or that is an expense that is still associated with the campaign. That information can be gathered from the television, radio, or whatever stations provided those commercials.